Good morning. This is your Kelso Report for Thursday, April 5th, and I'm your host, Clark Kelso. We begin today with some Ninth Circuit decisions involving criminal sentencing and habeas corpus, and then a California Court of Appeal, criminal law, and civil procedure. Let's get started with the Ninth Circuit and a decision involving criminal sentencing. In United States versus Onioso, the defendant pled guilty to possession of stolen mail and access device fraud, including the knowing possession of 15 or more unauthorized access devices with intent to defraud in violation of 18 U.S.C. Section 1029A3. The unauthorized access devices included credit cards and a spreadsheet containing 500 expired credit card numbers. Because of the large number of expired credit card numbers, the district court ordered a significant enhancement to the defendant's sentence. The Ninth Circuit reversed the enhancement, holding that the government was required to prove that the expired credit card numbers were actually usable for the purpose of obtaining money, goods, services, or any other thing of value. That's what it means to be an access device. The government did not prove that any of the expired credit card numbers had actually been used or were usable. So the Ninth Circuit vacated the enhancement and remanded to give the government an opportunity to submit such evidence, if any. Next, habeas corpus. On December 12, 1996, a Nevada jury found the defendant guilty of robbery with a deadly weapon, false imprisonment, battery with a deadly weapon, and battery causing substantial bodily harm. Direct appeals in state court were exhausted in 1997. 8 years later, the defendant filed his first state habeas petition, which was denied by the state courts. He then filed his first federal petition within 1 year of the state court denials, and then a year later filed an amended petition. The district court held that the running of the federal habeas limitations period, the initial running, was tolled because of the petitioner's mental state, although the court also held that the petitioner's mental condition did not excuse his procedural default on several of his state law claims. The court dismissed 4 of the new claims that were contained in the amended petition because it held those claims did not relate back to the timely filed first petition for federal habeas release. Well, the Ninth Circuit affirmed all of this in Schneider v. McDaniel, although Justice Noonan in dissent wondered how it was possible for the petitioner's mental condition to toll the federal limitations period while not excusing the petitioner's procedural default under state law. But aside from that, the court affirmed what obviously was a rather messy and confused habeas case. Next, we turn to state courts, the first case involving criminal law. The defendant was arrested for a DUI and then was convicted of multiple violations of the vehicle code. The court found true allegations that he had 3 prior driving under the influence convictions, 2 in California and 1 in Arizona. Based on the true findings, the court elevated his sentence from a misdemeanor to a felony under Vehicle Code Section 23550, which allows for sentence enhancement if the defendant had 3 or more qualifying convictions in the preceding 10 years. The defendant argued that the Arizona conviction could not be used as a qualifying conviction for purposes of Section 23550 because it did not rise to the level of driving under the influence under California law. The 4th District agreed with the defendant, holding that the Arizona conviction in fact was not a qualifying conviction. The problem here was that the Arizona statute makes it unlawful for a person to drive or be in actual physical control of a vehicle while under the influence if the person is impaired to the slightest degree. Well, that statute clearly can be violated by a person whose blood alcohol level would not qualify for a DUI under California law. So the 4th District held the Arizona conviction was not qualifying under California law. Next, we have a jurisdiction problem involving a national bank. In Wells Fargo Bank versus Baker, a national bank had sued California residents in Iowa and served them via substitute service with the Iowa Secretary of State as allowed by Iowa's long-arm statute. The national bank then obtained a default judgment against the California residents in Iowa and then registered that judgment in California pursuant to the Sister State and Foreign Money Judgments Act. The Superior Court vacated the judgment on jurisdictional grounds, and the national bank appealed, contending that the court had erroneously interpreted the Iowa statute to allow substitute service only when the contracting corporation was a resident of Iowa, which Wells Fargo is not. The 4th District agreed on appeal with the bank, holding that the Iowa statute, as it applies to national banks, is preempted by the National Bank Act because the Iowa statute infringes upon the power of a national bank to sue as fully as a natural person under state law. And that's a power clearly established by Title 12 U.S.C. Section 24, which provides that national banks may sue and be sued, complain and defend in any court of law and equity as fully as natural persons. And finally, another criminal law case under state courts. In People v. Wright, the defendant was convicted by jury of second-degree murder with personal use of a deadly and dangerous weapon, and an admission he suffered a prior felony conviction. The court sentenced the court sentenced the defendant to prison for 31 years to life. The 2nd District held the Superior Court had no sua sponte duty to instruct the jury on voluntary or involuntary intoxication causing unconsciousness, which was the defendant's basis for appeal. The defendant argued he was intoxicated involuntarily because he had been poisoned, and that there was a foreign substance that had been introduced into the cocaine he had been smoking. Well, the 2nd District rejected this argument, finding there was no substantial evidence of a poisoning, and that in any event, involuntary intoxication is not established when a defendant voluntarily uses an unlawful drug, not realizing it contains another illegal drug. And that's it for today's Kelso Report. Have a great day in the law.